What I'd like to do is just give you a little bit of perspective and focus first on the Open Meetings Act, and then the best use you might make of my time would be to do what I do on a regular basis as a volunteer for the Freedom of Information Foundation. I take calls from people about open meetings and open records issues and try to help. If you've got issues or things that you're thinking about doing or you've tried to do in the past to get access to records with the government, I'd be glad to try to help you here and share that information with the group. Actually, I need to go back a little further than when I was 30 years old and say that when I first came to Austin, I worked over in the Texas legislature. And in 1973, after the Sharpstown Bank scandal in 72, and that'll really age me, but for those of you who ever heard of the Sharpstown Bank scandal, there was a time, believe it or not, when the Texas legislature was dominated by special interests, and they would sometimes try to bribe public officials to pass legislation. That was a long time ago. But some of them got caught back then over trying to pass a bill that would exempt certain state banks from FDIC regulation and allow them to be under the supervision and regulation of state agencies that these same legislators could dominate and help out their buddies and have looser regulation of state banks. And they got caught. The FBI got them. And we had a throw the bums out session in election in 1972. I worked with a bunch of what was then called the Dirty 30. Out of the 150 members of the House of Representatives, there were 30 who stood up to the Speaker Mutcher, who was one of them indicted over this, and asked for an investigation. And somebody at the back of the room, after the votes came out, they had only these 30 members, all I think 6 of the Republicans, that there were only that many in the House at the time, and then other Democrats that stood up, and they said, those dirty bastards, those 30 dirty bastards. So they adopted the Dirty 30 as their moniker, and I got to work for a bunch of those folks. Lane Denton was one of them from Waco, and I was his administrative assistant in 1973 when the reform legislation under then Speaker Price Daniel was brought forward. We already had an Open Meetings Act in Texas, but it was really weak, and Common Cause had a model Open Meetings Act bill that they brought forward, along with Open Records Act, and Lane was the sponsor of what was then called the Open Records Act. And I got to work on that legislation. And Buck Wood, who is an attorney here in town, many of you probably know, was the lobbyist for Common Cause and on all this legislation and on the Open Meetings Act. We got campaign finance reform passed, the Open Meetings Act, the Records Retention Act. The Records Retention Act, I would point out to you, is not an exciting piece of legislation, and the regulations and rules through the state library are even more boring. But what that act does is to keep state agencies and local governments from destroying records for a certain period of time. They're scheduled in very detailed schedules so that they are actually still available if you want to come file a Public Information Act request for them. Because without records retention, you could go file all the Public Information Act requests you want, and they'd say, we don't have any documents like that. And let me just say, an aside, one of the biggest issues I've seen developing in the last few years since I've been practicing law in this area is a lot of agencies that think that an email somehow has a status different under the Records Retention Act than paper records, and they're dead wrong about that. And I've seen agencies develop policies that say, after 7 days, we're going to delete all our emails. Well, if you do, it's a criminal violation of the Records Retention Act. One of the things that Buck did to try to improve the existing Open Meetings Act that we had in '73 was to get adopted Section 551.143 of the Open Meetings Act, And I talked to Buck about this recently in light of the city council situation here. And he reminded me that what was going on up in Dallas, for example, was that where the law only prohibited the council from meeting in a quorum at one time, is there were 7 members of the council. The mayor would have meetings with 2 council members at a time, routinely. They would figure out what they wanted to do, and they'd have their full discussion about the issues right there. And by the time you got to the council meetings, it went like this. The mayor said, Council Member A, make your motion. Council Member B, make your second. Let's all vote. We're done. So he wrote a provision that said that you can still violate the act, a criminal violation of the act, if you meet in groups of less than a quorum for the purpose, if you knowingly conspire to meet in groups of less than a quorum of the governing body, for the purpose of secret deliberations in violation of the act. And he got that adopted in there to stop the kind of practice that he'd seen going on in mean old conservative Dallas. Now, with that act back there and knowing the history, that piece of the Open Meetings Act is a critical piece of avoiding just gutting the idea that the public gets to hear the process by which governmental bodies come to a meeting of the minds. The AG has written before, and there's court cases out there about this, that say that basically what the intent of the act is, of the Open Meetings Act is, and this provision in particular, is that in order for a governmental body to come to a decision, there is some process by which there comes to a meeting of the minds. And the public doesn't just get to see the point at which that meeting occurred. They get to see how that happened. They get to see between a quorum of the public, of the governmental body, they get to see who said what was the back and forth, how did they move, how did so-and-so move from this position over to this position, back to this position. They get to see it all along. I've used the analogy of a kitchen, that what the Open Meetings Act, and in a sense the Public Information Act does, is it says, you know, the public doesn't just sit down at the dinner table and have the food just served to them from their governmental bodies and said, here, this is what we've decided. You not only get to go back to the kitchen and watching them cooking this up, you get to see the recipe. You get to see every ingredient that got in it, and you get to see which cook put that ingredient in there and who was stirring it around and how they were doing it and so forth. Now, it has been a somewhat sad process to see the reaction to the county attorney's review of what the city council has been doing. I fought the battle when it was the mean old conservatives who were the governing bodies, and there were the people in power, and in the back rooms were making the deals. The right-wingers, that was my history in the early 70s. The Bill Heatleys and the Gus Mutchers and the Ben Barnes and those folks. And I worked on Sissy Farenthal's campaign, and we were fighting those guys on all kinds of things, but particularly on openness and responsiveness to government. And I have seen the same arguments now being made of defenders of liberal members of the Austin City Council that I heard back, and it brings echoes back to me of what I was hearing in the 70s. And to me, it is a matter of principle. Regardless, and I'm not going to say that anybody's violated the law, they created a criminal offense. But I know enough from the facts that we've listened to through the AustinBulldog.org, tape recordings of members of the council talking about how this worked. The best one, if you only have one to read or listen to, is go to AustinBulldog.org and listen to Mr. Martinez's explanation of not only how this system works, but why it's important for it to be done this way. Remember when I told you about the kitchen and your right to see these things? He said that what they were trying to do on these one-on-one council meetings, and it's not illegal for one member of the city council to talk to another member of the city council about public business. It's not illegal for them to even two of them to talk to another. what this provision is aimed at is when they do that, they're meeting less than 4 or less than a quorum for the purpose of daisy chaining those conversations together so that when you're done, a quorum or more has been involved in that conversation in serial fashion or round robin fashion or daisy chain fashion. That's what that's intended to stop, because it has the same effect as if they'd all gone into the back room together and cooked up the deal, had their debate back there, and then you come forward. And Mr. Martinez said that what they were trying to achieve was that level of understanding so that on Thursday we can minimize the line of questioning and the debate and move forward through the agenda. And he said, if there are some strong feelings and strong differences, the time to air those out and figure those out are in our one-on-ones and not necessarily on the dais. I read those and I just, you got to be kidding me. So what my summation is, forget the law for a minute and look at the principles that are supposed to be involved in transparency in government. Look at the principle underlying these laws. I really like many of the members, I'll say all the members of the Office of the City Council. I don't have anything personally against them. I'm sad for them. And I'm really disappointed that not a single one of them has stepped up and just said, you know what, I've looked at this and I don't care if it's against the law or not. We ought not be doing it this way. And thank goodness the mayor came close to that by having the work sessions. But another sad thing is watching that first work session. I didn't get to see the one yesterday, but I saw the one last week. And I felt sorry for them. It was as if those council members had never, do not understand how to have a fresh conversation with each other about an issue that they hadn't rehearsed before they got into the meeting where the public can see what's going on. It's as if they just didn't, if they weren't, they got so used to just talking these things out in the one-on-one process, they didn't know how to use a work session for real debate.